Here we are, officially at episode 100 of the Family Law Podcast. And to celebrate that, we've got new places to film and more controversial topics to attack. When parents separate, particularly when there's a lot of conflict, it is common for one parent to say that it's important to listen to what the kids want. That parent wants the other parent, or a judge, or an arbitrator to listen to the opinion of the children when setting up parenting arrangements after separation. The UN Convention on the Rights of the Child requires that children be heard in matters that affect them. But insisting that the other parent, a judge, or any other authority listen to the children is one of the most dangerous things that a person can do in family court. In some circumstances, judges view a parent making that request as evidence that parent should not be caring for the children at all. Hearing from the children can be tricky in family court, so it is the topic of this, the 100th episode of the Ontario Family Law Podcast. I'm Schuman, certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficult parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, and in fine bookstores. To some, giving kids what they want after separation seems like the obvious choice. Others point out that parents should not just give kids what they want when the family is intact, and doing so is bad parenting. Kids who just get what they want miss out on a lot of important lessons while considering the wisdom of each choice and can feel that they should always get their way. But in family court, the considerations are more complex. What children want does not overrule other considerations when a judge or arbitrator decides parenting matters. In fact, some judges are genuinely concerned about considering the children's wishes at all in high conflict separations. Judges do not want children harmed by their parent separation and do not want them harmed even more by the court process. As I covered in episode 79 and in my book, parents have a legal obligation to protect their children from conflict arising from their separation. So when making a parenting order, a judge must carefully balance hearing from the children about what will work best for them with the possibility that one or both parents is trying to manipulate the children to get what that parent wants, or to punish the other parent. That can lead to long-lasting harm to the children. Judges do not want to hear that the children have an opinion on the non-parenting matters. Children should not be involved in those issues, would ordinarily not be interested in them, and should not know anything about those issues or the court proceedings about them, much less have an opinion on them. A child knowing about any sort of financial matter is a clear indication to the judge that the child has at least one very bad parent who is deliberately doing things that harm the children. That parent is putting the child in the middle of a conflict over something the child should not care about. The parent who puts the child in the middle of conflict may find him or herself in a situation where winning is impossible and may face an order preventing that parent from continuing to see the kids. The guiding principle in family court, family arbitrations, and all parenting matters is supposed to be the best interest of the children. So everything that a separate parent does should be governed by what is best for the children. The laws that apply to parenting matters set specific factors that judges or arbitrators must consider when making parenting decisions. In episode 59, I went over those considerations, and I explained them in even more detail in my book. Importantly, the children's wishes is just one of 11 factors that the judge must consider in determining what parenting order is in the child's best interests. And even then, it is tempered by how well that child understands the decision and how freely that child has made that decision. However, how well a parent supports the child's relationship with the other parent counts as at least two factors in the determination of what parenting situation is in the child's best interest. Unlike the consideration of the children's wishes, which take into account the ability of the child to form an independent opinion, there are no considerations that water down the need for each parent to support the other parent's relationship with the child. Although family violence is another factor that a judge must consider. That leads to debate that judges have with themselves when faced with a request to allow a child to speak in court. On the one hand, the UN Convention on the Rights of the Child and some other aspects of Canadian law require that children be heard on matters that affect them to the extent that the child wants to be heard. The views the child is expressing are his or her own, and expressing those views is important to the child. On the other hand, judges do not want children to make adult decisions, especially when the child is being pressured in those decisions by one or both parents. When a child is a foot soldier in the battle between the child's parents, that child is inevitably a casualty of that war. When parents force children to take sides in a dispute between those parents, the end result is very often some very serious mental health problems that can plague the child throughout his or her life. Very often, when a parent is pushing very hard for a child to be heard and to have taken sides, judges are very suspicious of that parent who wants the child to be heard, and very concerned that parent is a bad parent who is prioritizing winning and will sacrifice his or her child to achieve that victory. But this does not mean that the child's views are not important. They can be critically important, and listening to those views can lead to the best possible parenting plan after separation. But children almost never want to have to pick sides between their parents. Children want to make sure that what is important to them is protected while their life goes through the huge changes associated with parents separating. The band Everclear released a song called Wonderful about the experiences of kids in divorce. One verse explores what is really important to children in divorce. It goes,
"Want the things that I had before, like a Star Wars poster on my bedroom door. I wish I could count to 10, make everything be wonderful."
Click the link to see that full video. It is worth the watch. Hearing what is important to the child can help parents turn their focus away from their battle and towards making the best arrangements for that child. What judges and arbitrators want to hear about from kids is not what parent the child likes most. Judges and arbitrators want to hear what things are important to the child that the parenting plan or order needs to protect. The things that it is important for everyone to know after separation are things like, is it really important for the child to stay in the same school, or would the child like a fresh start? Is the child concerned that having new homes will mean losing important friendships? What activities are important to the child? Are there sports that the child really enjoys and wants to continue? Is it important for the child to stay on the same team? Does the child want to stay in the same clubs? Is one parent more involved in a sport or activity or better able to support the child in that sport or activity? Is one parent better than the other at helping with schoolwork? Does one parent better understand the child's needs, especially any special needs? And is one parent better at making sure that those needs are met, or making sure that the school, sports, teams, activities, and others are addressing those needs? Does one parent's home give the child better access to friends, school, activities, and other comforts? Is the other parent willing to move to or make arrangements to make the child feel equally comfortable at both homes? Do the parents both understand what is important to the child? There are over 100 other episodes of this podcast now available that cover the breadth of difficult family law topics. To find more of them, obviously you should get my book, but also subscribe. Like this episode if you are finding it helpful, and hit the notification bell to find out as soon as new episodes become available. There are some more episodes on parenting, alienation, and child support coming soon. If a child is not getting along well with a parent, that is something else a family court judge, arbitrator, or parenting mediator will want to know about, but not to cut that child off from that parent, unless the relationship problems are the result of abuse that has been verified by a Children's Aid Society or has resulted in that parent being convicted of a criminal offense against the child. In most circumstances, what judges will want to hear about is what is causing the relationship difficulty, including hearing what the child says the problem is. Family court judges want to make orders that fix these relationship problems. Parenting mediators want to understand the problem so they can mediate a solution that fixes the problem. Sometimes differences in parenting styles are a problem for the child. Sometimes the child feels that one parent is ignoring the child's needs. Sometimes there was an event that put a wedge between the child and one parent, or perhaps drew the child closer to the other parent. Sometimes the problem is not with the parent, but the child's desire to be closer to friends. And in a small number of cases, the problem is one parent deliberately alienating the other parent. What the child says about a parent will often clearly indicate when the other parent is alienating that child from the first parent. This is often because the child's views about a parent have no rational basis, or based on events that did not occur, or that the child should not know about, or that give them no cause to be angry towards the parent. When a judge finds out that the source of the problem is in a parent-child relationship, the judge tries to make an order to fix that relationship. In cases of alienation, that order can be the opposite to what the child wants. It cuts the child off from the alienating parent. But for the other types of problems, the order tries to fix the problem, or at least encourage the parents to fix whatever is causing the child to have concerns. As a rule of thumb, a parent who wants the child's views to be before the court to pick sides will often find the judge does the opposite to what the child says he or she wants and cuts off the favorite parent from the child. but where a child is focused and explains what things are important to the child and needs to be included in a parenting order, the judge will be very interested in hearing that. To summarize, hearing what is important to kids is important for separated parents and in family court, but having children pick sides most definitely is not, and can lead to huge problems for a parent trying to get a child to pick a parent. The UN Convention on the Rights of the Child guarantees the children the right to have a voice on matters that affect them, but having a child say they don't like a parent or forcing a child to choose is not a child-focused approach. Often the issue is not the child wants to show more love for one parent than the other. Usually it comes down to the practicalities of life, like dad doesn't do homework with me, or mom won't take me to swimming or cheer practice, or I don't like dad's food, or mom always has to work late, or dad lives closer to my friends and I want to spend more time with my friends. These are all child-centered reasons why a child may want to change to a parenting schedule. Under the 2021 changes to the family laws, which required a child-centered approach to parenting issues, these concerns of the children are reasons to adjust the parenting schedule and parenting responsibilities so that each parent is doing as much parenting as he or she is able to do. They are not reasons to restrict the child's contact with the other parent. If you need some more general family guidance, or you need to understand Ontario family law better so you can make better decisions, if you need to know the best parenting options after separation, or if you need to better understand how finances work after separation or divorce, or if you need some tips for how best to make these difficult types of decisions, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBookstore and Amazon for the Kindle version, or you can download it. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. Because it's always best to get a lawyer who can give you expert advice that's specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter and Mastodon at @SchumanFamLaw, and finding me on LinkedIn. I'm also on Threads. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio version of the Ontario Family Law podcast in all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They are also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.